Question: how can you tell when Nick McLeland is lying? Answer: his lips are moving.
It's time for you guys to start being journalists.
Before an angry Andrew Baldwin left the courthouse, 13 News overheard him speaking to Richard Allen's wife, saying, "It ain't over. The world's watching. The world sees what's going on."
Good morning everyone, my name is Michelle, I hope you're doing well. Welcome to another video. It is Wednesday morning, the 5th of February. We're talking Delphi today, and we've got a state's response to the defence's motion to correct error. As predicted, Slick Nick wants the motion to be denied without hearing. So guess what Judge Gull is going to do? Yeah, she's going to deny it without hearing. We expected that. We also expected Nick McLeland to play sidestep and sometimes out-and-out lie. And 10 pages of a response here, which is exactly that. So we're going to read it in its entirety. First, just let me say, Megan Boswell trial, the jury is now seated, and the trial starts proper with cameras in the court at 9 a.m. which is 2 p.m. my time. I will be live to stream that trial on this channel about 1:45 my time, so that'll be 9:15 Eastern, and then whatever that is in your local time. Okay, without further ado, let's go. Now comes the state of Indiana by prosecuting attorney Nicholas C. McLeland. Respectfully objects to the defence's motion to correct error and would ask the court to deny the same without a hearing. Of course you would. None of this is unexpected. The defendant's motion does not warrant a motion to correct error because a motion for safekeeping filed by Carroll County Sheriff is not a critical stage of proceedings, and the evidence concerning Brad Weber, Ron Logan and Stacey Eldridge is not newly discovered evidence to warrant a new trial. The state would ask the court to consider the following. Safekeeping order. Let's zoom in here. Safekeeping order and 6th and 14th Amendments. That the defendant claims that his 6th and 14th Amendments were violated because he was deprived of counsel at a safekeeping proceeding, also not a hearing, a proceeding. Okay. November 3rd, 2022, and that proceeding was a critical stage where he was entitled to an attorney. Well, of course he's entitled to an attorney. If you don't think he's entitled to an attorney, we've got a bigger problem than I thought. But he didn't say that. The defendant further claims that since he did not have counsel at a hearing, the conviction should be overturned. Indiana Code 353311(1) states that upon motion by the sheriff alleging that an inmate is in a county jail awaiting trial, is in danger of serious bodily injury or death, or represents a substantial threat to the safety of others, the court shall determine whether the inmate is in imminent danger of serious bodily injury or death, or represents a substantial threat to the safety of others. It shall order the sheriff to transfer the inmate to another county jail or a facility of the Department of Correction. So I hope you're going to say the defendant can overrule the sheriff or the court, say, look, I don't care, I want to stay here. Or are you going to try and suggest that little Ricky, all 5'4" of him, was a threat to the guards or whoever else? The guards didn't even know he was there when he was in Carroll County Jail. Nobody knew he was there. I don't even know where they were keeping him. A basement somewhere, a little hidey hole, a cupboard. Alright, the state does not require the court to have a hearing to make this determination. The court can make this determination based on the motion alone. Okay, great. Again, the defendant can overrule it. That the defendant in this case was taken into custody on October 26, 2022 and housed at the Carroll County Jail. That an initial hearing was held on October 28th, where the defendant entered a plea of not guilty. The court advised the defendant of his right to counsel, and the defendant notified the court that he would hire his own counsel, which he did. Kathy paid $5,000 to an attorney, and Nick McLeland knows full well that this happened because that attorney spoke to Nick McLeland directly. He at no time stated that he had counsel. Lie! You lie! You know he had counsel. It doesn't matter whether he stated it or not. You know he had counsel. You know it. See order hearing attached to State's Exhibit 1. That after the initial hearing, the defendant was moved to the White County Jail due to overcrowding. Oh, that's the first we've heard about overcrowding, so that's why he was moved to White County Jail. That's a sidestep, isn't it? That's a sidestep. Oh, this move was unavoidable because there was overcrowding at Carroll County Jail. Again, where were they keeping him? Because the regular guards didn't know that he was even there. That's a lie. That has to be a lie. Is there any way we can find out how many inmates were in Carroll County Jail October 26th through 28th, 2022? Is there any way we can find that out? He was not moved to the White County Jail due to any safekeeping order. Oh, okay. Then on November 2nd, 2022, the Carroll County Sheriff, Tove Bleasenby, filed a request by the Sheriff of Carroll County, Indiana, to transfer inmate from the custody of the Sheriff to the custody of the Indiana Department of Correction for safekeeping, commonly referred to a motion for safekeeping hearing attached State's Exhibit 2. Yeah, but Tove Bleasenby was not the Sheriff of White County. Rick had already been transferred to White County Jail at that time, so it should have been the White County Sheriff that stepped in and said, we need this guy transferring because we can't keep him safe. Once again, the defendant could have overruled that and said, no, I want to stay here. And if he had counsel, like Kathy paid $5,000, that counsel could have advised Rick such. November 3rd, the state received an email from attorney Brett Gibson stating that he would not be representing the defendant, herein attached to State's Exhibit 3. Interesting. That's interesting that it just happened to be the same day. The same day that they transferred him to Westville. How convenient. What a coincidence. November 3rd, the court granted the sheriff's motion without a hearing and determined that the defendant was in imminent danger of bodily injury or death or represents a substantial threat to the safety of others, not based on any acts or alleged acts by the defendant, but by the insistence on public information, noting that it's extremely dangerous and put all public servants in a dangerous situation. Oh, I see. So, the bloodlust argument. So, Rick wasn't a threat. The public was the threat. This is clever. It's not stupid, you know. This is clever. It's lies, but it's clever. That in this order, the court further noted that the defendant intended on hiring private counsel, which he did, further supporting that no attorney had entered their appearance of counsel of record for the defendant. Well, there was nothing to enter at that time. But the attorney had made himself known. You knew Rick had an attorney. At the very least, you should have held fire doing anything to Rick until you absolutely clarified the status of the attorney. That a motion for safekeeping is not considered a critical stage of the proceedings where the defendant is required to be present with counsel. Oh, so you can do all this behind his back, can you? Shady shit, this. That the sheriff had standing to file the motion of safekeeping because although the defendant was moved to White County Jail, he was a Carroll County defendant. He was only moved to the White County Jail because the Carroll County Jail did not have sufficient room to house him. It's clever, this, you know. How many nights did you stay awake, Nick, dreaming all of this up? The very first time we've heard about overcrowding at Carroll County. Look, if I'm wrong here, just let me know in the comments. if it was known that Carroll County Jail was overcrowded, and that's the reason why they transferred him to White County. All right. Okay. Affidavit by Tob Leesenby. That Judge Diener was the presiding judge over the case at the time, and therefore a jurisdiction over the case further was within the jurisdiction within Indiana Code 3533.11.1 to make a ruling on the motion without a hearing. Well, yeah, Judge Diener then promptly recused himself, didn't he? Cool. That, as of the filing of the motion for safekeeping, the defendant did not have an attorney of record. Yes, he did. You knew he had an attorney. The Indiana Code 3533.11.1 does allow the defendant to request a post-transfer hearing, which is what occurred in this case. 7 months later, the defendant requested a hearing on the safekeeping order, and one was held on June 15th, 2023. So 7 months later. At the June 15th, 2023 hearing, the court found that the defence's allegations were untruthful and not well-founded and denies the motion to modify the safekeeping order. I think we're way past that now, aren't we? I think we're way past saying what was stated at the June 15th, 2023 safekeeping order was unfounded and was just lies, based on all of the stuff that came out at the trial. That's an out and out lie. It was then, and it still is. The court further found that the safekeeping order was reasonable and necessary to ensure the defendant's safety and to prevent serious bodily injury to himself, hereby affirming the court's order. Look, you drove Rick Allen into psychosis just to get him to confess. Therefore, the defendant had a right to object and exercised that right, and his counsel failed to show the court that the safekeeping order was unnecessary. The court found that the defence did not meet their burden, but that the evidence presented at the hearing did not support the allegations. Just lies. Lies. The defence filed an additional verified motion for immediate transfer of custody on September 18th, 2023, which the court denied without a hearing. And she's going to deny this without a hearing as well, yeah. All right. That the defendant's due process rights and constitutional rights were protected throughout the course of the case. Under the Sixth Amendment of the United States Constitution and Article 1, Section 13 of the Indiana Constitution, the right to counsel only applies to critical stages of the prosecution, where the absence of counsel might derogate from the accused's right to a fair trial, State versus Taylor. Further, a stage of the proceeding is only critical if that is one where incrimination may occur and where the opportunity for effective defence must be seized or foregone. The right to counsel is not a generalised protection for all purposes. It is not a right that is implied just because questions of law may arise. So you don't have a right to an attorney just because there's questions of law. So you're expected to represent yourself and know the law without an attorney. The motion for safekeeping does not touch on matters of guilt or impact the ability to have a fair trial. Oh, really? It's a mechanism for housing the defendant in a penal facility pending trial that will keep him and others safe. Yeah, well, you failed. The defendant is not facing the advocacy of the prosecutor with respect to his guilt or innocence of the criminal charges. It's further not a stage where incrimination may occur or where the opportunity to present a defence to the charge must be seized or forever be lost or impaired. It has been found that the filing of information is not a critical stage, the probable cause hearing or the initial hearing are not critical stages. What is a critical stage then? It is safe to surmise that given those rulings, a motion that does not even require a hearing would not be critical. Okay, all right, moving on. That since this was not a critical stage, the defendant did not have a Sixth Amendment right to counsel, and he was denied this. Man. Because Rick Allen is expected to know the law, is expected to be able to represent himself, because it's not a critical stage. Define critical stage, like properly define it. That even if this were determined to be a critical stage in the proceedings, any Sixth Amendment right to counsel would be reviewable under the harmless error analysis. Of course it would, yeah, of course it would. Good old harmless analysis. That the defence cite chronic, I think that's spelt wrong. You spelt it like chronic stress or chronic pain in the ass. All right. As precedent to overturn the conviction, but they do so because they misunderstand the case. The defence believe that the case says a harmless error analysis is precluded because the defendant was denied counsel at a critical stage. However, the case states that Sixth Amendment violations raise two questions: whether a Sixth Amendment violation has occurred and whether the constitutional violation was harmless. Prejudice must be an element of the constitutional violation to warrant reversal. In Chronic, the issue was ineffective assistance of counsel, not lack of representation of a critical stage. In determining if not having an attorney at a critical stage reaches the level of a violation, the harmless error analysis is used. That the lack of a hearing for safekeeping motion on November 3rd and the lack of counsel before the decision was made by the court had no effect on the jury's verdict and therefore is harmless. The jury did not find the defendant guilty because a determination on his safekeeping was made without a hearing on November 3rd and no attorney appeared. Nor did not having an attorney or a hearing at this stage permanently deprive the defendant of the opportunity to raise any claims or assert any defence. Yeah. Thanks for that, Nick. How about Rick had the right to refuse the removal of him from a county jail to Westville, but he didn't know that at the time. You're saying he was expected to know that, to say, no, I'm not going, that he was expected to know that because he doesn't have a right to counsel at that moment. And then you send him to Westville, where he becomes psychotic because of his treatment at Westville, which has a direct impact on the jury, because if those confessions had never happened, what did you have against Rick? What did the jury actually have that would have convicted him? Answer: not a lot. The lack of counsel must be complete to apply the presumption of prejudice. The presumption of prejudice only applies when the error infects the entire trial process and necessarily renders it fundamentally unfair. Well, I think we've got a good example of that right here, ladies and gentlemen, don't you think? The chronic exemption is exceedingly narrow and is only applied in cases of non-representation throughout the entire case. Due process under the 14th Amendment, as it pertains to the Brad Weber testimony. The defence argues that the defendant's due process rights under the 14th Amendment of the United States Constitution were violated because the state presented testimony that Brad Weber arrived home in the white van at 2:30, knowing that the testimony was false before it was elicited or failing to correct it once it had been elicited. The defence cites a video located in discovery from the residence near the Monon High Bridge, so the Sandyford property. A video that was included in the discovery turned over to the defence and that the defence had the entire time of trial. And so did you, Nick. So did you. That's the point. So did you. You knew about this. You knew. And you lied. That the exhibit presented by the defence in the form of a YouTube link that is not identified as an item of evidence by an Indiana State Police number and therefore is an improper submission for consideration with the court. He is so sly. So sly. It is unverified by legitimate means as to date and time. It's your exhibit. You have it in the discovery. It's your exhibit. Man, defence allege that the time in the video is off by 12 hours without any proof of said allegation except their apparent ability to tell the time by simply looking at the daylight and moonlight in the video. They further make assumptions about the content of the video. They present zero evidence to support said allegations. It's your exhibit, Nick. A simple answer is that a motion to correct error only applies to newly discovered evidence. From the defence's own admission, this is not newly discovered evidence, but rather evidence they had been provided long before the trial. And I wish the defence had found that and understood the significance of it. But ultimately, Nick, you knew this evidence was right there. You knew it. You knew it was a lie when it was being spoken at the trial. And it was a key piece of evidence that persuaded the jury that Rick was actually guilty. The defence chose not to present it at trial as part of their trial strategy. It was a trial strategy by experienced defence trial attorneys. Oh, so now they're experienced. Therefore, it's a moot issue because it's not newly discovered evidence. And that's the argument that the appeals court are going to make as well. It wasn't newly discovered evidence. I think they're going to have to go down the route of ineffective assistance of counsel. And I know that sounds really horrible because Brad and Andy and Jennifer have been so darn good. But I think it's the only way this is going to get through to the appeals court, because it's technically not newly discovered evidence because it was in the discovery. So the fact that the defence didn't use it to counter the claims being made, I think they have to go down the ineffective assistance of counsel route. Let me know what you think. That at best this is impeachment evidence that the defence could have used when Brad Webber was on the stand testifying. Evidence which is merely impeaching is not available grounds for a new trial under the rules concerning newly discovered evidence. But it is under ineffective assistance of counsel, however horrible that sounds. Further evidence must be more than impeachable or cumulative, must not be reasonably discoverable before trial, and is also evidence that would probably result in a different verdict. Well, this definitely would. This definitely would. Finally, the testimony by Brad Webber was not the exclusive evidence the state used to convict Richard Allen. No, but it was jolly good, wasn't it? It was a jolly good gotcha moment. That was a lie. But that at the time, the jury absolutely believed, because there was no reason for them not to. Brad Webber was put on the stand multiple times, and the defence had every opportunity to cross-examine him, which they did. If anything, this evidence is no more than impeachment evidence that the defence chose not to use. The defence is not permitted to request a new trial to change strategy when the chosen path fails. Well, they had their wings well and truly clipped because their chosen trial strategy wasn't allowed. So they were making the best of a bad job here. And we all know that they tried their darndest for Rick. But that is what the appeals court is going to say, in my opinion, that this wasn't newly discovered evidence. So they have to go down the route of ineffective assistance of counsel, I think. All right, Ron Logan. Reese Davis' claim of confession by Ron Logan. That the defence next argue that Reese Davis claims Ron Logan made a confession to him. Said claim is being newly discovered evidence entitling defendant to a new trial. That any information pertaining to Ron Logan fails under the state's motion in limine concerning third-party motive. This is the biggest sidestep of all. The defence had 3 days to present evidence to meet their burden for third-party motive. They mentioned Ron Logan but failed to meet their burden with the court. They chose not to present this evidence at that hearing. They also did not present this evidence when they renewed their motion during the trial. This now seems to be an effort by the defence to use a motion to correct error as an effort to circumvent their burden concerning third-party motive. That this evidence, along with the video surveillance evidence from the residence, was received by the defence on January 30th, 2024, as evidenced by the discovery release herein attached as Stakes Exhibit 7, that the defence team consisting of 3 experienced defence trial attorneys made a choice not to fully explore or present the Reese Davis claim, which the defence admits was contained in discovery. That the alleged confession was made to an inmate at the Department of Corrections named Reese Davis, who is serving 50 years for dealing in methamphetamine. 50 years for a meth deal. 50 years. Why has he got 50 years for dealing meth? That law enforcement interviewed Reese Davis and submitted him to a polygraph at his request. Mr. Davis failed the polygraph miserably. Yeah, but polygraph results are not admissible in court. So that's irrelevant. That's irrelevant. Nick, that's irrelevant. You do know that polygraph results are not admissible evidence in court because they're not reliable. Mr. Davis gave a statement that alleged Ron Logan confessed to him that killed the older girl first and then took the younger one away from the scene, that he killed the second victim later and then brought her back to the scene. Okay. That he went back to the scene after search parties searched his property and moved the girls to another location. That he removed the cell phone battery from the girl's phone and left the phone behind. Where was that stated? That's news. That's breaking news. That he took the girl's clothing from the scene and burnt. No, you're wrong. No, he said he burnt his own clothes because he got Libby's blood on his clothes, so he burnt them. Not the girl's clothes. He never said that. Many of these details are directly contradicted by the evidence. Others have no evidentiary support. Well, actually, what about the stuff that does have evidentiary support? What about the fact that Ron Logan's phone was at the crime scene just before 8 p.m. and just after 10 p.m. on the 13th of February? What about his phone being in the vicinity of the Monon High Bridge at 2:09, exactly the time when the girls were there? How about that? Are you going to mention that? No? Okay. Even with the alleged information from Ron Logan about the box cutter, there would have not been enough to establish probable cause to arrest Ron Logan. No evidence places him at the scene of the murders. Yes, it does. His phone places him at the scene of the murders. His phone does. On 3 occasions, his phone was in the area where the girls were, both alive and when deceased. Unlike the defendant, who left an unspent round at the scene, which your own expert, Melissa Oberg, could not definitively say it came from Rick's Sig Sauer P226. She had to fire that round to make any comparable marks to what were on that unspent round. She had to compare apples with oranges to get that result. And also, she could not exclude other weapons. So, no, that's wrong. You can't use that anymore. Your own expert gave contrary testimony. He himself asserted was never in anyone else's possession and put himself on the bridge at the time of the abduction. But Ron Logan's phone puts him on the bridge at the time of the abduction. Does Rick Allen's? Is there any actual evidence that Rick Allen was there at the same time as the girls? No. Wore the same clothing as Bridge Guy. Alright, so a blue coat and blue jeans. Alright, so such unusual clothing, isn't it? Stacey Eldridge expert opinion. That the defence finally alleges that an affidavit by Stacey Eldridge, so she was the defence's phone expert, supports that dirt or water did not cause damage in the auxiliary jack in order to log wired headphones were plugged in and unplugged. They allege that this is newly discovered evidence that would probably produce a different result at a new trial. Stacey Eldridge testified at the trial for the defence. She did not submit any report, log or any other information that supported her position that the log accurately supports that headphones were plugged in and later unplugged. That this opinion was only supported by her testimony at trial. So, are you saying that testimony at trial is not enough? Prior to her testimony, Stacey Eldridge had only done one other forensic phone analysis and had only testified one time prior about a forensic phone analysis. Stacey Eldridge used to work for the FBI. Stacey Eldridge's experience speaks for itself. Stacey Eldridge only gained the education to be able to testify to forensic phone analysis as recently as 2023. So, that the bulk of her expertise is in computer and network forensics, not cell phone forensics. Okay, see her CV attached. That the state calls Sergeant Christopher Cecil on rebuttal to testify about headphones. Oh yeah, that he had to Google. So, what an expert he was. This is insane. Sergeant Christopher Cecil did testify that one plausible explanation for the log entry is that there was dirt or water in the jack that caused a malfunction. But that should have triggered a sensor in the phone that would have said that there was water damage. Talked about this in a previous video. And you provided no evidence that the phone was damage due to water or dirt. Part based on the condition of the phone was found in, how long it was outside before it was found, and his knowledge and experience as a forensic examiner. Look, you didn't provide any evidence that that phone was damaged due to water or dirt. You didn't even say that the phone had anything on it. You said that phone was clean. This was also based on facts found through the investigation, including that the phone did not move after 2:32, although Brad Webber's van came by 12 minutes later. Okay. On February 13th, that there's no headphones found with the bodies. Unlikely that someone returned to the crime scene after 2:32. Well, what about Ron Logan's phone then? How did Ron Logan's phone ping twice in the vicinity of the murders? At 8 p.m. and just after 10. Removed the phone from the underneath the body of Abby, plugged headphones into the phone, and then kept those headphones in for 5 hours, unplugged them, and then put the phone back underneath the body. We don't know where the phone was before the headphones were plugged in. Not difficult, is it? That the defence expert Stacey Eldridge sat in the courtroom during Sergeant Cecil's testimony, and that the defence had an opportunity to recall her as a witness to rebut Sergeant Cecil's testimony, but chose not to. That there is nothing in the logs, reports or extractions that would indicate whether or not the phone had some kind of water damage. Yeah, but it should have had. If it was water damaged, that kind of evidence should have been logged. You said that phone was clean. Whether or not there was water damage can only be determined by physically examining the phone, which Stacey Eldridge did not do. At best, this is impeachment evidence that could have been brought out in testimony during trial in an effort to impeach Sergeant Cecil's testimony. This is not newly discovered evidence to warrant overturning the conviction. It's arguably ineffective assistance of counsel, though. The same analysis that was used in the above evidence concerning Brad Webber and Ron Logan would apply to the evidence as well. It is not newly discovered evidence, but is impeachment evidence, and therefore cannot be the basis of a motion to correct error. Wherefore, the state of Indiana, by prosecuting attorney Nicholas C. McLeland, you've been proper slick here. You got to give it credit to him. He's clever when he wants to be, isn't he? But you can see right through him. The court denied the motion to correct error without a hearing and for all just and proper relief in the press. Yeah. So Judge Gull is going to go, oh, whatever you say, Nick, denied.